Thank you, attendees. Thank you, participants, for joining us. It's great. We have 9 participants so far, in addition to the speakers. So that's a pretty good turnout. A few more minutes and we'll start. All right. People are joining. Well, I suppose it's on my clock. It's 6 a.m. and good time of the day, they say. You know, wherever you are, whether you're in Moscow, in Europe, or in Hong Kong, or in any other part of the world. But welcome to the panel. My name is Burd, and I'll be one of the co-moderators of today's panel. And today's panel is called "The State or Not the State." And the issue that we'll be discussing, relate to the ability to pierce corporate veil of the state-owned companies, and how, especially in the context of enforcement of arbitral awards, of collecting against the states or state-owned companies. Well, first and most important probably order of business is to thank our sponsors, and I'll try to bring up the name of the sponsors on the screen. Just bear with me for a second. There we go. Let's see if this works. And here are our sponsors, and one of the our panelist, Antonia Mottironi. She is with Monfrini, Bitton, Klein. They're Swiss litigators based in Geneva. And we thank you, Antonia, and your firm for so gracious sponsoring of this conference. So I'll try to unshare it at this point. Here we go. So just a few more technical notices. One notice is that this panel today is recorded, and my understanding is also been translated live on YouTube, and it will be posted on YouTube. So you just bear in mind that and just act accordingly. We also have 2 types of participants. One type of participants, they are active users and passive users, and the inactive users. The active users, I'm trying to the best of my abilities to promote to panelists, which essentially give them the ability to ask questions and to be part of the discussion. The problem that, just to bear in mind, that I have to do speaking and clicking at the same time, which might not be a very efficient way to promote the attendees, to promote the active users to the panelists. So bear with me if some of you are not been promoted, not able to ask questions directly right away, but I'll try to do the best I can. We now have 24 participants, including 3 moderators. It's a great outturn. And first, let me introduce, and then, yes, and if you want to ask any questions, please raise your hand. There is an option to raise hand somewhere at the bottom of your screen, so please feel free to push it. And if you don't see this option, just unmute yourself and ask questions and ask your question. Okay, that's pretty easy. We try to be pretty liberal. Of course, bear in mind that one thing that we keep in mind is that we only have 50 minutes for the panel, and we need to cut it off very quickly. And it will cut off exactly at 6:50 or whatever time is on your end. Just brief introduction of the speakers, and I'll let them to do their discussion. Antonia, as I said, she's with the law firm of Klein and Monfrini, Bitton, Klein in Geneva. She focuses on asset recovery, complex multi-jurisdictional civil and criminal proceedings, cross-border insolvency, enforcement of foreign judgments and awards. She was admitted to Geneva Bar in 2013, graduated from the University of Geneva, earned degree in Swiss law and a master's in international European law. And she used to work for the Swiss Tax Authority. So she might be able to give you some tips from the inside, perhaps. And Cathalijne van der Plas, she's a partner. She's based in Amsterdam, in the Netherlands. She's a partner with Jahae Raymakers. She conducts an international practice that consists for the main part of international judgment enforcement and civil asset tracing and recovery with an accent to financial crime matters. Cathalijne holds a PhD in private international law and also is an assistant professor in private international law at the University of Amsterdam. Furthermore, she is a fellow of the International Academy of Financial Crime Litigators and co-chairs the Asset Recovery Chamber of the Institute of Financial Crime. So with that introduction, I'd like to invite the speakers to start their discussion. And the way we plan our discussion, just to give you a little overview of the panel, that we'll try to spend about 15 to 20 minutes maximum on the discussion, and then we'll try to engage and answer your questions and respond to your queries. And of course, let you make any comments that you want to make. Antonia, would you like to proceed?
Yes, sure. Well, thank you, Jean, for this very kind introduction. And so good morning, good afternoon, and good evening from Geneva, Switzerland. I would like first to give you an overview of the mechanism of enforcement of foreign awards in Switzerland. So first, Switzerland is a party to the New York Convention on Recognition and Enforcement of Arbitral Awards. So in principle, foreign awards are enforceable in Switzerland. The classic way to enforce these awards is to request the attachment, I mean the freezing of assets to the civil court where the Swiss assets are located. I will not enter into too much details on all the legal requirements of Swiss law to obtain these freezing orders, but it is important for the creditors to know that they have to identify the Swiss assets before seeking enforcement in Switzerland. This is because we are a civil law jurisdiction, and we also have a deep culture of privacy in Switzerland, as you may know. And so a creditor will not receive any support of Swiss courts to locate these assets before that creditor requests enforcement of an award. So in our case study that was distributed to you by email, the typical assets that could be found in Switzerland would be operative accounts of soy people SRL based in Geneva, simply because it is a company incorporated in Geneva and needs bank accounts to run its day-to-day business. It is also very common that accounts are open where banks grant lines of credit to trading companies for particular transactions or investments. The most active banks in Geneva and Zurich are ING, BNP Paribas, Société Générale, Credit Suisse, or Gazprom Bank, for instance. So, beside this Swiss bank accounts, which are very famous to everybody on the planet, it is also important to stress that Geneva is the first hub in the world for commodity trading. So besides bank accounts, you can also manage to freeze other assets, and the typical assets you can freeze are claims that your debtor has against a trading company based in Geneva. What is interesting is that you can freeze already due claims, but also future claims, and it's very typical in commodity trading to find contracts that provide for successive deliveries of goods for a period of, for instance, 1 year, and you can freeze these future claims as well. So in our case, you could, Russian power could try to freeze the claims that that soy people in the Republic Altramentie has against its subsidiary in Switzerland, and Russian power could also try to freeze the claims of soy people Geneva, the subsidiary, that are owed by other independent trading companies based in Geneva. Now, of course, the issue in this case is that the award is issued against the state and the enforcement is sought against a state-owned company. So in that type of cases, Swiss law provides for additional requirements, as certain assets of the state are protected by the immunity of execution. So in that case, the creditor will also, so Russian power will also have to show three things. The first point is that it will have to show that the underlying unperformed contract that was the origin, what triggered the arbitral proceedings, was not concluded by the state in the exercise of its sovereignty. So in our case, the unperformed contract concerned the construction of a soy processing factory, and under Swiss law, it is crystal clear, irrespective of the issue of the state of a state-owned company, that that type of activity is not in the scope of the exercise of sovereignty of a state. So, as such, because of the nature of the contract, soy people or well, any defendant in enforcement proceedings could not invoke that they are protected by the immunity of execution. The second point that Russian power would have to show is that the Swiss assets that creditor managed to locate in Switzerland are not assigned to a task of public authority. And here, apparently, at least, the Swiss assets that were identified are only assigned to commodity trading activities, so that they are not protected by the immunity of execution of the assets of a state. That's so. The good news for the time being is that the immunity of execution cannot be invoked because of the nature of the contract and because of the use of the Swiss assets. But the creditor will have to show a third point. It's last but not least. And it is a very particular requirement of Swiss law is that where the Swiss assets of a foreign state are involved, the creditors must show that the claim itself has sufficient ties with Switzerland. This means that the claim must be borne in Switzerland or the main part of the contract where or should have been performed on Swiss territory. And in our case, well, the parties to the underlying agreement are the Republic of Atramonti and Russian power, and the contract had to be performed on the territory of the Republic of Atramonti. So in that case, typically Swiss courts would deny enforcement, not because the activity or the assets are strongly connected with the exercise of public authority, but only because that lack of ties with Switzerland. This requirement of sufficient ties with Switzerland is really the main pitfall to enforcement of awards and judgments against states, in our country. So in practice, Swiss courts would usually stop their reasoning here and would not address, in fact, the questions of whether or not soy people, whether the holding in the Atramonti Republic or the Geneva-based company subsidiary. So Swiss courts will not address the issue of whether or not soy people can be treated as the alter ego of the Republic of Atramonti. And actually, there is no case law on that type of issues. And just to conclude, I would say that it is almost impossible, or I would say it's very difficult in Switzerland to successfully plead that a state-owned company is, I would say, the same legal person or the alter ego of the state. And the main reason is that a creditor should show that the detention of the state-owned company by the foreign state had the only purpose of hiding assets, defrauding creditors, or committing criminal offense. So it has hard pleadings against foreign states in the light of diplomatic relationships with Switzerland. And in my practice, I have only seen assets held by the state or held by state-owned company frozen in the context of large-scale criminal proceedings for corruption and or organized crime committed at the highest level of certain states. And well, that one is maybe a bit out of the scope of the topic of today.
Thank you, Antonia, and appreciate your very brief, concise explanation. Of course, the focus of our today's panel is on whether state-owned companies can be liable or can be executed against their assets for awards that are issued against the states or vice versa. So, yeah, thank you for the Swiss view of this. And we also had the fact pattern that I neglected to mention, but I hope that you all reviewed about that involves the company, the company in the Republic of Atramonti that was in the contract between the Russian company and Republic of Atramonti that was breached, and the award was issued in Moscow, and then the Russian company is now trying to enforce this award in various jurisdictions, and that's some of the hurdles, some of the issues that have been explained by Antonia. And now, what if the Russian company tries to attempts to enforce this award and collect in the Netherlands? What what can it do there, Cathalijne? Is it going to be successful?
Well, we'll see.
It depends.
It depends, of course. It always depends. The fact pattern shows that there are 3 potential assets in the Netherlands, being cargo ships that are every now and then in the port of Rotterdam, possibly debts of Dutch trading companies, and possibly funds in bank accounts of the Geneva entity, so the People's Soy Sarl. In general, you could say that it's relatively easy in the Netherlands to obtain permission for pre-judgment or pre-award attachments. There are ex parte proceedings. Of course, there are some exceptions, but in general, it's ex parte. And it takes you only 1 or 2 days after having submitted your request for attachment to get an answer from the court, an approval or a refusal. And then you can go ahead. Normally you will have to file the main proceedings within 2 weeks after the moment of you start attaching assets. But here in this fact pattern, we already have a Russian arbitral award, and as the Russian Federation and the Netherlands are both a party to the New York Convention, this means that the award can qualify as main proceedings for the sake of attachments in the Netherlands. And the advantage of that is that you can already make attachments before even initiating the exequatur proceedings in the Netherlands. And the obvious advantage is, of course, that then the judgment debtor might not yet be aware that you are trying to execute the award in the Netherlands. However, as today's subject includes immunity, there is a big but to this relatively ease of obtaining attachment. If we assume that the court gave permission for the attachment, then the bailiff is the one who will start executing, will making the attachments. And if the bailiff, the Dutch bailiff, has a reason to think that the assets might be protected by immunity from execution, he will have to inform the Dutch Minister of Justice, who can prevent the bailiff to proceed. And usually then you end up in summary proceedings between the bailiff, the party requesting attachment, the Dutch state, and possibly joined by the foreign state who it concerns. And then the court will decide whether or not there is immunity from execution. And like in many other jurisdictions, this is difficult for the attachment creditor, as immunity from execution is upheld in the vast majority of cases. We had a few decisions of the Dutch Supreme Court a couple of years ago, and where it decided that the burden of proof is on the attachment creditor to prove actually that the assets concerned are in use or intended for use by the state for other than non-commercial purposes. And those decisions have been highly criticized in legal doctrine, because it makes it now more or less impossible to make attachments against a foreign state. But thank God, there is now a development in lower case law that the direct use is sufficient. So if you as an attachment creditor can make plausible that the direct use of the asset is commercial, then you will be fine. This has been affirmed now a week ago by the Advocate General in the Netherlands, who is advising the Supreme Court in a pending decision. So perhaps the Supreme Court will clarify in a couple of, well, probably months, that its earlier case law should be read as meaning that it's about the direct use. If I return to the fact pattern, in this case, the problem is that, or problem depends from on which side you are, is that the assets are not directly owned by the state. So the Swiss entity can only invoke immunity from execution if it can be identified with the state of Altramonti. And so you need a direct veil piercing, and this is rarely applied under Dutch law. It's really ultimum remedium, so it's not very likely that there will be an identification. You also see a different approach in lower case law with referring to Article 2 of the United Nations Convention on Immunities. Although that convention is not signed by the Netherlands, it is some provisions of it are applied nevertheless. And in the definition of that convention, you will find that equal to the state are entities that to the extent that they are entitled to perform and are actually performing acts in sovereign authority of the state. Again, if we have a look at the fact pattern, I would say that the Geneva entity does not fall under that definition. So it's not likely that it can invoke immunity from execution. And even if it could, then I would say that in this case, it's likely that the direct use of the assets is commercial, as also already Antonia explained. So it seems that from a Dutch perspective, the problem, immunity is not the issue in this case, but there is another issue because the assets don't belong to the judgment debtor and you can only attach assets of the judgment debtor. So how to convince the court that it should nevertheless allow the attachments. And there we have very interesting case law, recent case law in the Netherlands at the moment. It's now pending before the Supreme Court, but both the Court of First Instance and the Court of Appeal allowed attachments under a 100% daughter company of Kazakhstan, Samruk, a joint stock company, with regard to an arbitral award against Kazakhstan. So there you had a discussion on the table. We have an award against the state, Kazakhstan, but we want to make attachments against a daughter company of Kazakhstan. And in this specific case, the courts ruled that finally that there was no factual economic independence vis-a-vis Kazakhstan, and it was impossible for Samruk to conduct its own policy. And so the court then assumed, by lack of another explanation, that Samruk has been incorporated for the purpose of hiding assets of Kazakhstan for its creditors. So this could be the way out in the fact pattern, although I see one difference that might make it a bit more difficult, that here in the case study that we have, PeopleSoy is actual business operations. So I think it's more difficult to make plausible that PeopleSoy is incorporated with the purpose, one of the purposes being hiding assets. But well, this would be, I think, what you should try in the Netherlands. So now back to Jean, because time is running fast, I see.
Yeah, thank you, Cathalijne. I think it was right to the point presentation. It's a good addressing the fact pattern. Meanwhile, we did have a question from one of the participants. So please unmute yourself and just please go ahead and ask the question if you don't mind introducing yourself as well.
Good morning. Thank you very much. My name is Victor Prokofiev. I'm a legal interpreter based in London. Thank you so much to the moderator and the panelists. That was excellent, very informative. A couple of questions, if I may, in my capacity as a linguist. So the questions are going to be legal and slightly linguistic as well. it appears to me that you seem to be drawing a distinction. I think Antonia drew a distinction between attachment and freezing. Is there any legal difference between the two? And do I take it that freezing in French is saisie arrêt? And secondly, when you say a company is owned by the state, for the purposes of drawing a distinction between jus imperi and jus gestionis, how do you determine whether a company is owned? Does it have to be 100%, 75%, 51 plus 1? Thank you so much.
Thank you, Victor, for questions. Just for the first one, when I just said attachment or freezing, it's just an issue of translation. Well, for me, it's just the same concept. Well, we rather talk about attachment in civil proceedings, where really we enforce an award before civil courts, and freezing order is more appropriate for criminal freezing orders. But it is the same notion that the saisie arrêt of French law, indeed. And with respect with the terms owned, well, usually it is 100% or more than 50%, and there is also a case that discusses whether own is or does also means controlled by, which, well, it's different. It's different legal analysis, because the direct detention would be would focus on the shareholders. So is the state of shareholders or bodies of the state are the majority shareholders, and where we discuss the control, it would be rather just to look at the actual detention of the company. So it can appear to be 100% held by the private law company, but it is actually controlled by the state.
Thank you, Antonia. And just to switch gears a little bit, I will talk about the enforcement of this award in the United States, or other actions, legal actions that can be taken there. And in the United States, the prejudgment attachment against state-owned companies, against the states, is highly unlikely. So before you even think about attaching the assets of states and state-owned companies, you do need to enforce the award, which is by itself, of course, it's not an easy process. And it could be a lengthy process, especially in cases involving sovereign immunity, because we have a Foreign Sovereign Immunity Act that provides jurisdictional immunity, not only immunity from the execution, but also jurisdictional immunity, immunities from the legal process. So you would need to overcome this hurdle. Now, there is a special exception to immunity for enforcement of arbitral awards, and that's the good news, because of course this award presumably would be subject to the New York Convention. It would be subject to an exception. So, presuming that you got the judgment in the U.S. court based on the award, what do you do next? And of course, the judgment is against the state, it's not against the company itself, and that's the biggest issue, because of course, at least by default, they're not the same entities. And the analysis that is used by U.S. courts is based on the decision, a 1983 decision in the First National Citibank versus Banca para el Comercio Exterior de Cuba, which is it's called a Bansec case. It's a very famous case for this analysis. And in this case, the Supreme Court, the case went all the way to the Supreme Court, and the Supreme Court held that there is a possible to disregard corporate entity of a state-owned company and to consider a state-owned company as alter ego of the state. But there are certain conditions for that needs to be met. The first condition is that the instrumentality, and we use the term, which is in the Foreign Sovereign Immunities Act in the United States, instrumentality, which means a separate legal entity. So this instrumentality was established to shield the sovereign from liability, which is I think it's pretty straightforward. Any company, or not any company, but in a lot of cases, companies are established to shield the owners from liability. So by itself, this should not present the biggest hurdle. But then there is the one big one is the sovereign ignored corporate formalities in running the instrumentality, and the sovereign exercised excessive control over the instrumentality. And that's where the really difficulty is, because this is a very fact intensive analysis that requires the court to go through the different aspects of how the company was managed, how it was ran, who owned it, who was issuing the decisions, and so on and so on and so on. So there are a lot of factors that the court would consider that. For example, if for example in our fact pattern, there is one of the points is that the company had an office in the Ministry of Agriculture, that would shift the balance towards the recognition of the company as alter ego, or the fact that the company was directly financed by the state. But then on the other hand, the company was, as Cathalijne mentioned, indeed it's a bona fide company, was engaged in a bona fide business. It had its own employees, on its technical staff, its own assets, separate bank accounts. So it's a very difficult balancing test. Now there's another factor. There are some interesting factors in this fact pattern connecting the company with the head of the state, with the president, Sceleratus, who was apparently very generous towards his relatives and appointed one of these close relatives as the president of the company, and his daughter was the owner of the bank that was providing financing for the company. And then also there's another factor here, also a very important factor, this decree number 36, that prevented, essentially directly intruded on the ability of the company to pay the debt to the Russian power, and that was essentially precipitated the whole the arbitration. And would that be considered to be an act of state, act of sovereign state, especially in light of the pandemics, of the global pandemic, or would that be considered some type of act that would be that would be favoring local creditors, or favoring the president's own family? So there are a lot of factors, there are a lot of evidence that would be required. If you would want to go in the U.S. court and present this case to the U.S. court, you would need to do a lot of background work to do that. Now, there is an additional there's an additional condition that the courts in the U.S. would consider, and again, it's based on the Bansek case, is that there has to be some broad equitable principles that the doctrine of corporate entity recognized generally and for most purposes. It will not be regarded when to do so would work fraud or injustice. And that's also important. That's also one of the required conditions. There has to be some fraud or injustice to the creditor in order to be able to enforce, to consider the company as being an alter ego of the state. And it goes both ways. If for example, you have a award against the company and you want to enforce the award against the assets of the state, the same analysis applies. These are very similar analysis that would need to be taken in the account. The political corruption, of course, there's some indication there was perhaps some political corruption involved in this fact pattern. is this a factor? And the courts say, and the courts, and again, in the Bansek case, and in the Bansek case, the court said that, yeah, it could be a factor, but it has to be proven by evidence. So simply simply a general allegation of corruption would not suffice. So you would need to, again, you would need to be able to obtain evidence and to show that indeed the political corruption played a role in the specific claim. Now, in the Bansek case, by the way, there was a situation where the Cuban bank, the Bansek, sued the American bank, the Citibank, on the letter of credit, and the Citibank counterclaimed based on the taking of assets by the Cuban government, and that's exactly. So the claim was based, from the U.S. bank was based on the claim against the government that they tried to offset the claim that was brought by the Cuban bank, by the Bansek. So these are the main issues. There's some other aspects that that we can talk about. For example, a correspondent account in the suspect pattern. You have this First Bank of Antonia, which has a correspondent account. And again, there are two issues here. One, for example, if there is a fund, there are funds in this correspondent accounts, that belong to.
На звонке, sorry, я слушаю.
Hello? Yeah. So there are funds that in this correspondent account that could be potentially owned by the debtor, and or a situation where there is a claim against the bank itself, a claim against Bank of Atramonti. So in this second scenario, it's interesting because there could be also potential an argument that the Bank of Atramonti itself is alter ego of the state because of the close connection between the owner of the bank, who's the daughter of the President Skeleratos, and the bank itself. So but again, just this familial connection might not be enough. So you would need to show something more to show that this bank is actually alter ego of the state itself, and then you might be able to have a claim against the correspondent account itself, that money that are held by the foreign bank in the United States. And the last very quick point before we have 10 minutes left, so I'll just try to 1 minute. There is Cathalijne and Antonia mentioned about what assets you may have in their respective jurisdictions. Now, in the United States, you may be able to obtain discovery from for example, correspondent bank accounts or from the banks that would relate to the letters of credit. And this discovery can be obtained on an ex parte basis, and in some cases, in some instances, the courts even issued gag orders preventing the banks from disclosing the fact of discovery to the debtor. So it's a possibility to use the to use the enforcement proceedings in the United States, not per se to obtain assets in the United States, but to obtain information that is useful to enforce for the enforcement all over the world. Also, there were cases in the United States where the creditors tried to find the recognition of alter ego with the U.S. courts to use this, not to attach the assets in the United States, but to use this judgment of a U.S. court, recognize an alter ego to enforce judgment in other countries, in Europe, in European jurisdictions. So these are possibilities that could be explored in U.S. courts in connection with this fact pattern. And we have questions. Please go ahead.
Hi there. This is John Fels from PCB litigation in London. Thanks for a very interesting session. I just had one question, which is, there have been some recent instances where there are competing interests, both claiming to run particular states. I was wondering whether the panel had any thoughts about the potential issues this could cause in determining whether or not an enterprise set up by one of those competing interests was in fact a state-owned enterprise, therefore whether sovereign immunity might apply.
Thank you, John, for your question. Well, I have to confess I don't really have an answer, but maybe I found a provocative one at the end. Just from the Swiss perspective, well, you know that we are a neutral country, and so Switzerland recognizes states and never governments. So I would say, well, my genuine answer would be that, well, as long as the state is involved, irrespective of whether or not it is an illegitimate government or a legitimate one that brings claims in Switzerland, as long as it is a state, there is no particular issue. Now, I would try to solve the question by just to determine whether or not that the company is owned by the state. Swiss court should determine that person to the foreign law. So I think it would depend on whether this illegitimate government set up the company based on the ordinary company laws, or set up that company based on an extraordinary law that was entered into force after a coup, for instance. And well, if you reach the conclusion that pursuant to foreign law, that law was not compliant with the constitution, my guess would be that the company itself is not validly incorporated, so there is actually no legal entity. That would be my solution.
In respect of time, I also see that there was another question from Victor Prokofiev. What if the state-controlled entity is not an incorporated entity, but say a foundation? Would the respective countries use the control test as opposed to owned? Maybe Jean, do you want to respond to that?
Yes. I think, yeah, the Bansa case really talks in terms of control, not necessarily ownership. And there are cases that explore the degree of ownership, whether 50% of the state ownership is enough or 75% ownership enough. So it's a sliding it's a sliding scale. So the control would certainly play a very important role. And like I said before, the U.S. courts very fact-oriented, at least in this type of case. This case very fact-oriented. So you would need to really explore the degree of control of this foundation. Maybe the foundation itself was just a sham to shield the sovereign from liability, and there were fraud involved. Then, of course, there would be very good reasons for the court to disregard this foundation as a protection.
Yeah, I think for the Netherlands it would be more or less similar, as the question is whether you would have to make plausible that there is, well, that the foundation is in fact an organization ruled by the state and used for hiding assets. But well, it will be difficult to have a proof for that. But that's what would be most relevant, I would say.
Yeah, and it's in Switzerland I have exactly the same answer than Cathalijne, so my answer is very brief. Maybe it lets the room for other questions.
Yeah, we have a few more minutes, 3 more minutes. Anyone, any questions? Yes, please go ahead. Leonid, please unmute yourself.
Yes, hello.
Yes, go ahead.
Probably this is a question for Cathalijne. in relation to the Kazakhstan case she has mentioned, but views of other panelists are also welcome, of course. So if I got you right, you're mentioning that the court assumed in that Kazakhstan case that a specific legal entity was set up to hide assets, and it interrelates with the previous question, I think, in relation to foundation. But if we're talking about commercial companies, what, in your opinion, or based on that court decision, what are the factors that are taken into account to make a conclusion that, in fact, the company was set up to hide assets, if it is not a foundation, which is a bit separate scenario, but a commercial company doing real business?
Yeah. No, that's an interesting question. And I think when I read the decision for the first time, I was like, oh, this might also be a helpful decision for just in fraud cases where no state's involved, but fraudsters who make use of a web of entities. Because it's so often that you end up with a court decision against the fraudster, but the assets, of course, are in different entities. So but in the Kazakhstan case, the factors that were taken into account by the court are that the fact that Samruk was had needed approval for decisions from Kazakhstan. It was not allowed to take decisions that were against Kazakhstan as sole shareholder. Kazakhstan was able to appoint the director, the board of directors of the entity, and to fire them at any time. The president of the board was the prime minister or the president from Kazakhstan. So there was a lot of ties between Samruk and Kazakhstan. And I would say that more in general in company law, you are right that in the Netherlands we have these foundations that doesn't have shareholders, so that makes it more difficult to well, it's not piercing, but to make clear that the foundation is in fact controlled by the ultimate beneficial owner. But so the information you need would just be very factual if you can show that it is the entity is used, or the foundation is used for the benefit of the UBO. I think you will, well, this decision gives you a good chance. Although I must say that in this Kazakhstan decision, in fact, the court was applying Kazakhstan law. So it was the court ruled that according to Kazakh law, there was an abuse of the corporate protection. But I would say that it would not be very different if they would have applied Dutch law. So I don't know if one of the others want to respond to this as well, Jean, Antonia, or maybe panelists, just participants. Do you have a different view or input? Then please tell us.
Well, I think at this point we came to the end of our panel. We just almost maybe a few minutes late, but I think it was interesting. Thank you very much, the panelists, for your presentations, and also thank you to all the attendees and all the participants for your questions and for your attention. And I think at this point we should be disconnecting and letting other conferences to start, other panels to start. Thank you very much, everyone.
Thanks. Thanks, Jean.
Thank you.
Thanks, Jean. Thank Cathalijne. Thank you, everybody.